you know, 10 or.
A little plus or minus.
Be all set? Okay. I'd like to bring the Town of Wappinger Zoning Board of Appeals meeting to order. Could I have roll call, please, be?
Mr. Delacorte?
Here.
Mr. Lorenzini?
Here.
Mr. Shaw?
He's here.
Mr. Barr?
Here.
Mr. Colati?
Here. First order of business tonight is acceptance of minutes from September 14th, 2021. Has everybody had a chance to review?
Yes.
Any comments, changes, revisions?
Fine.
Okay, could I have a motion, please, to accept the minutes as written?
I make a motion to accept as is.
Have a second? All in favor?
Aye.
So moved. All right, second order of business tonight, appeal number 217739, Gilbreth and Duran Beltran, seeking an area variance section 24037 of district regulations in an R15 zoning districts, where 10 feet to the side yard right property line is required. The applicant can provide 8.1 feet for the construction of an 8x10 shed, thus requesting a variance of 1.9 feet. The property is located at 286 Ketchumtown Road and is identified as tax grid number 615602544878 in the town of Wappinger. Could I have a motion, please, to open the public hearing?
I'll make a motion.
You have a second?
Second it.
So moved. Okay. Would you kindly step to the microphone and don't be shy. And for the benefit of the public and the benefit of the board, just a brief description of what you need and why you need it, simply like you did last time.
I am Elga Chave, the wife of Gilbert. We're seeking for the variance for the shed that is, as you say, 8.1, and the law says 10 feet
Got
in
it.
the property.
We all did a site visit on Saturday, so we all see what's going on here, exactly what you got. Understand the topography on the property, and then we see basically the adjoining property as a parking lot, really. I think it was pretty straightforward. You know, we had a few questions you guys answered for us while we were there doing the site visit. And if you guys have any other further questions for the applicant.
Yeah, I just want to confirm, is it construction side is 8x10 or 8x12?
8 by 12.
8x12, right? Okay, yes. So I think we need to correct that one, this one.
We'll make that correction
Okay,
on the
right.
agenda and on the variance.
Yes, okay.
8 by 12, but won't have any impact on the variance.
No, all right.
Okay. Yeah, thanks for
That's all.
clarifying.
Yeah.
Any other questions from the board?
So-
Anybody in the audience have any questions regarding this application? No? Okay. Could I have a motion from the board, please, to close the public hearing?
I'll make a motion to close the public hearing.
Could I have a second?
Second.
So moved. All right, could I now have a motion to either grant or deny the applicant the variance?
I make a motion to grant variance. Okay. I like to make a motion to grant the applicant the requested variance. After reviewing the application, the information you provided here and site visit, I think requested variance is not significant. Alleged difficulty is self-created, but granting the variance will not create substantial detriment to nearby property. There is no physical method option available for applicant to achieve the benefit based on the property what you have. Proposed variance will not cause any adverse effect or impact on environmental or physical condition of neighborhood. So I make a request to grant the applicant.
Okay, could I have a second?
Second.
Okay.
Myself again.
Can I have a roll call, please, B?
Mr. Delacorte?
Yes.
Mr. Lorenzini?
Yes.
Mr. Shaw?
Yes.
Mr. Barr?
Yes.
Mr. Colati?
Yes. Okay, so your variance has been granted.
Thank you.
Yeah, you're welcome.
You'll get a call from the building department in the next few days for your permit.
Okay. And you're free to go.
You can stay also if you'd like. But I don't,
Have a good night, thanks. All right, third order of business tonight is an interpretation, appeal number 17740, Ron Evangelista et al., seeking an interpretation of Section 24052C, 24021D, 24015, non-residential schedule definition of mixed uses of the district zoning regulations in an HM zoning district. The application is seeking an interpretation of the zoning administrator, Barbara Roberti's interpretation of the zoning code dated June 20th, 2021. The property is located at 2357, 2361, 2363, 2365, New York State Route 9D, and as identified as tax grid numbers 6157010, 048643, 057642, 057654, 059643, 040637 in the town of Wappinger. Okay, does the applicant have representation tonight that would like to speak?
Apparently no one is here from Ken Steiger's office
Okay,
yet or at all.
okay,
Did you send him an agenda?
And I did receive a letter from Mr. Stenger saying he'd be here tonight
okay,
and indicated he hoped we'd be able to set a schedule for trying to process the application and submissions.
okay.
And also, just if I might, Mr. Chairman, the application was filed. I think we should formally send a copy, here's Mr. Stenger now. Send a copy of the application to Gasland and its representatives to formally involve them in the proceeding.
Gotcha.
Okay, that's it. Mr. Stenger.
Okay,
It's a wrap.
Mr. Stinger, right on cue. Almost, a little late, but you're right. Yeah, that's correct. Yes, but we read the interpretation, and now we were all set to listen to any representation that would like to speak. We're all set for you, well, if you'd like to speak on behalf of the applicant tonight.
What the board thought is, this evening, if you wanted to make a little statement about it, and then I advised the board that we'd probably be setting a schedule to allow for submissions.
Interpretations before a board are, in my experience anyway, fairly rare. And so every board has its own way to approach them. My feeling is that the argument I wish to present to this board is really an argument at law. I don't think the facts are in dispute. It's the way we read the statutes. It's the way we apply the statutes. We have a process. We went to the zoning administrator and have her decision. We timely filed here as we need to do. And what I propose to do is we read the statutes, and we read the statutes to say that you can't have that gas station in that district. Now, I don't want to make the argument here.
Sure.
And we read the statute and say it's incomprehensible in the way it says, or the language it uses, with respect to the ability to put an apartment on top of a gas station in this district. And I think the arguments are I know, I don't come to you to make a frivolous argument. I'm not here to make a speech one way or the other. I think what we understood we could do here today is and of course with Nick Ward-Willis, who's an old colleague being heard, is submit to this board under a schedule our legal arguments, somewhat akin to what we do in a courtroom when we have a question of law as opposed to who's telling the truth, who's not telling the truth. Because very much the issues I bring here today, are issues of law. And so that's what I was proposing and hoping to do. I don't know what conversation we're having with Nick beforehand, but he always talks when I'm not here. But
He
that's
didn't say a word tonight.
That's a joke, by the way.
Yes, right.
He's been speechless, but he was here on time.
That's it. So I would think that with counsel for the board, that we would be able to work a schedule of submissions that would allow me to put my argument out,
Okay.
allow Mr. Wood to read it, evaluate it, would allow Nick an opportunity to respond, and very much in a motion practice that I would have the last ability to file a response to him, and then I think your attorney and you, as a board, will consult and make that decision. Look, I was around, I sat in one of the planning board meetings, and that my opinion of what I saw that night, I think you understand without me saying it. There is a public hearing, perhaps, posture in this process. I don't know how that gets addressed, but I would be absolutely in favor in any procedure that we can eliminate that kind of damaging public input to a serious question. I would like to be considered seriously on my argument and not on what color T-shirt I'm wearing to the meeting.
Sure.
I respect this process very much, which is why I have taken this way to express our argument rather than bring people in T-shirts to rant and rave. And that's my spiel about
Understood.
what I think about it, this process, and why I'm here.
Understood. Yeah, go ahead, Tom.
No, should we, want to let Mr. Willis?
Go ahead, yes.
Thank you, Mr. Chairman. Nicholas Ward Willis with Keenan Bean for Gaslamp, a property owner. As a procedural matter, I agree with Ken that that's probably the best way to proceed. I want to talk with Tom and Ken. We can agree upon dates and the process, and then have Tom present that to the board. Substantively, we think Ms. Roberti got it correct the first time, and that she's correct, and we'll put forth that in our arguments. In addition to the substantive arguments about the zoning code and how it's correct, there's some procedural questions that this board will need to address before it even reaches Ken's question, is whether this is even properly before this board, given the fact that the planning board has already rendered its determination,
Understood.
which is the subject of an Article 78, which I think renders your determination moot at this point because you don't have the authority to undo what the planning board has already granted, which would be in effect. And like Ken said, we don't want to get into the arguments tonight, but Ken went a little bit into it, so I'm just going to go a little bit into it. We also have questions of standing as to whether his clients have the authority to appeal that opinion. So that's why I think the briefing on the papers is the right way to go, rather than perhaps having public hearings when the facts aren't in dispute. So I'm in agreement with Tom's suggestion and Ken's concurrence that this is best off agreed on a briefing schedule.
Sure. All right, thank you. Well, we had thought, right, that we would adjourn the interpretation and discussion till the October 26th meeting, that zoning board meeting, and to do the other comments.
So perhaps, okay, the board would adjourn until October 26th, and then perhaps with the board's agreement, we could work out a schedule amongst ourselves that you submit it, get it to the board. Well, we'll submit everything and then see where we go from there. I think that the issues, aside from the factual issues, but we have to address, I guess, standing's going to be raised. The issue of public hearing, I'd like to hear your views on that, about the ability not to have one. Because the code says normally, and normal practice is a zoning board would have a public hearing. So,
That's open for discussion now. I just got done with a public hearing over the town of Plattekill, in which my client, who I represented, retained the tail end of this and proposed to put a drag strip. And he needed a variance. And the variance questions are an area variance, not this. The area variance questions are very straightforward, I mean, like, do you have an impact? If you do, how do you mitigate it? We all know that, right? There were 4 public hearings. Over 1,000 people showed up to testify, and not one of them had a thing to say about the issue before the board. And all they wanted to do was make their speech and frankly insult the board and the applicant. And anyone who took the process seriously. I don't know, the law provides for a public hearing, but I think that the board has the ability to set the scope for comment. We're going to be presenting a legal argument. And Nick and I have done this before in other forums, so it will be an informed legal argument. If there's public comment, perhaps it should be just limited to the legal argument, not to the emotional response. See, I don't know
Well, what I could say is there may be two sub-things. Maybe they have to make an interpretation about whether you need a public hearing on a review of an interpretation. But I just thought you should touch upon that in case you find anything, because obviously the board always wants to welcome public input and public involvement, because that's the very basic of local government, right? Correct, so I think we want to go carefully in that area.
We
Yeah.
can certainly speak together and
Yes.
come up and give you some guidance
Yes.
on that. I think that's
Right.
important, because we recognize the public's input.
I agree 100%. Yeah, if we have we'll have this discussion, and if ultimately a public hearing is needed or required, we certainly limit the discussion to the action, really, right?
No, I think that's right. It's a prerogative of the chairman as to the comments that are supposed to be heard, and he can set that up
Correct.
in front and control that.
Correct.
It's just, you have to work this out, because you don't want, well, you saw that last time, you don't want someone showing up in his t-shirts going, how come I can't talk?
But I'm not in a position to tell the board that.
But they're asking for the rest.
Yeah, right, we can
Well-
certainly provide that.
We'll have that discussion, we'll work out the details.
So, but I think just to be clear, if the board's adjourning this to October 26th, the submissions will come in. I think the board and myself are gonna have to discuss that. I don't think you should expect that on the 26th, there'll be an instant, decision.
Correct.
No, I think that's fair.
You know,
I
so-
imagine by the 20, well, we have to get a schedule of submissions.
Karen.
Right, so when do we want to do that, by conference call tomorrow?
Yeah,
Yes,
we
I
can
think
do,
that's
yeah.
That'd be fine.
Is
I'm
that
fine
right
with
with
that,
you?
sure.
Yeah.
Absolutely, yeah.
Well, it'll probably be Friday,
I'm good for Friday. Presuming the board is deferring to whatever schedule Mr. Wood as their council will agree.
As long as we're back on the 26th.
Yes, absolutely.
Okay.
Correct.
Yeah, I just suggest you put a page in on Ken.
Oh, that would,
That was a joke.
There's an answer.
was it 5,250 words now?
Yeah, that's it. All right.
Okay,
We
So
can
then-
do That makes sense, thank you.
yeah,
I don't
absolutely.
think there's anything else.
No, they would include.
And we are
they
gonna
concluded
formally
tonight.
send you a copy unless you wanna waive that.
Right, we can wait. I mean, you got a copy? I've got it from the litigation papers, we were never provided with a copy.
Okay, well, yeah, I'll send it to you.
Sounds good.
Okay? So based on it, saves you doing
Version
that.
or the version C, I'm not sure.
The version where you acknowledge that.
Yeah, to adjourn, yeah.
All right, that would be great.
We're good?
Very good.
So we'll see you on the 26th.
Yes,
Okay, great. Thank you.
thank you.
Have a good night.
Do you adjourn by
So you
motion?
want to make motion?
No. Oh, okay, it's not, it's not a public hearing.
I did not, I apologize, I was rude. I did not represent you that my client is Dan Edgewell from Gaston was present tonight.
Gotcha.
So you do whatever revision the ordinance was.
Thank you. Thank you for doing so. Okay,
Okay, good.
I think we're good.
Thank you very much.
Thank you.
You want to
We
make?
need- Do we have to make, excuse me, Barbara, do we need to make a motion to adjourn that?
No,
No.
it's just a discussion.
Okay,
It was on discussion.
thanks.
or
Okay, so
discuss?
we're good. Thank you, guys.
Yeah, yeah.
So with no further business before the board tonight, could I have a motion, please, to adjourn?
I make a motion to adjourn?
Can I have a second?
Second?
All right,
Good night.
all in favor?
Aye.
So moved. We are adjourned.
Shortest public meeting I've been to.
Yes.
What he is, it's great.
We like it that way.
Good night, all, thank you.
Good night, thanks, Tom.
Thank you. Well, we don't have to be there. Did we adjourn, right?